The Civil Rights Act of 1866 is a foundational topic for the national portion of the real estate exam. This landmark legislation prohibits any type of discrimination based on race in all real estate transactions without any exceptions. This absolute nature is the most common way the concept is tested on the exam. You will often encounter questions that try to blend the Civil Rights Act of 1866 with the Fair Housing Act of 1968. While the 1968 Act has specific exemptions for certain types of housing, like owner-occupied 2 to 4 unit dwellings or private clubs, those exemptions never apply to race because the 1866 Act remains the superior authority on that specific protected class. If a question describes a situation where a seller is discriminating based on race, your answer should always reflect that the action is illegal, no matter how many other criteria the seller might meet for a Fair Housing Act exemption. The historical context of this law is also significant for exam purposes. It was passed by Congress just after the Civil War to ensure that all citizens of the United States have the same right in every state and territory as is enjoyed by white citizens to inherit, purchase, lease, sell, hold, and convey real and personal property. However, its full power was not realized in the private sector until the landmark Supreme Court case of Jones v. Alfred H. Mayer Company in 1968. In that case, the court ruled that the 1866 Act prohibits all racial discrimination, both private and public, in the sale or rental of property. The court held that the law was a valid exercise of congressional power under the 13th Amendment to eliminate the badges and incidents of slavery. This is a common phrase to watch for in exam questions, as it links the 1866 Act to the 13th Amendment rather than the 14th. Another critical distinction for the exam is how this law is enforced. While violations of the 1968 Fair Housing Act are typically handled through administrative complaints with the Department of Housing and Urban Development, or HUD, a person who has been discriminated against under the 1866 Act can take their case directly to federal court. There is no administrative requirement they must satisfy first. This means the legal remedy is often faster and involves the federal judiciary immediately. A common trap on the exam involves the mention of a real estate broker. Students often think that if a broker is not involved, certain rules do not apply. While that might be true for some parts of the Fair Housing Act, it is never true for the Civil Rights Act of 1866. Whether a person is using a licensed agent or selling their property by owner, they cannot discriminate based on race. To help you remember this for the exam, use the mnemonic phrase, 1866 is race, and race is always wrong. This reinforces that the year 1866 is tied exclusively to race, and that there is never a legal justification or exception for racial discrimination in real estate. Examiners like to create scenarios where a landlord lives in one side of a duplex and refuses to rent the other side to a minority applicant. They will ask if this is permitted. While this might be the Mrs. Murphy exemption under the 1968 Act for other protected classes, it is strictly prohibited because of race under the 1866 Act. Therefore, the answer will always be that the landlord has violated the law. You must keep in mind that the Civil Rights Act of 1866 covers both real and personal property, which is another detail that occasionally pops up. By focusing on the absolute prohibition of racial discrimination and the lack of any exemptions, you can navigate these trick questions with confidence and ensure you do not fall for the common confusion between the different fair housing laws.